Hello, everyone. Thank you so much for joining us here on Immigration Talk Show. We do have a very interesting webinar lined up, and soon our guest is also going to join us. But before that, let me tell you that I'm going to be a host for today's session, and I'm Napasa. Thank you once again for joining us. So, before we head on, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And friends, joining us today is going to be none other than Attorney Prashanthi Reddy from the law offices of Prashanthi Reddy, a familiar face who makes it a point to join us possibly every week. And she has been in immigration, and it's been almost 3 decades now. So I think it's a great opportunity for us as well because we have her to share expertise with us. Hi, Prashanthi. Thank you so much for joining us today as well. Welcome.
Hi, Nipasa. Good to be back.
Thank you. So, friends out there, do check out Attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. And today's discussion is going to be on H1B lottery update. As we all know, it's trickled out now. And we do have some important updates as well with regard to travel restrictions for non citizens. So, we're going to discuss that as well. And Prashanthi, maybe you could tell the folks out there who have joined us what can they expect from this session today?
Well, we will obviously be talking about the lottery because that's in the news. We have received notification that they have sent out all the lottery results. And so if your case is still showing submitted, that means, you haven't been picked in the lottery. So that's one thing to keep in mind. But there could be another lottery in July or August. Last year there was, depending on how many people file their picked cases. If they don't file, then USCIS might do another. I mean, do the same lottery, but pick more people from the same lottery. But it's not going to be obviously as many cases as we picked this time. The second lottery is always smaller, so we have to wait and see. But as of April 1st, you should start filing your H1Bs sooner the better. You have 90 days to file. The selection notice will have the end date, the deadline to file your H1B. So keep that in mind and also look to the selection notice to see which address to send it to. So that's with reference to the H1B lottery. With reference to restrictions on travel, we've been hearing a lot of buzz on who can travel, who can't. I mean, every day I have clients calling me to find out whether it's safe to travel or not. Some of it is, of course, just anxiety on the part of people because they're hearing all these stories. So we are trying to see what is, what level of caution should be taken when traveling, who should travel, who shouldn't, and what to be aware of when you're traveling. So that's another thing that we're going to break up during this call.
Yes, we will, friends. So stay with us and you can join us also in this discussion, participate by commenting, or you can call us. In the number to dial in is 425-436-6335, and the access code is 988-888. And another best thing is that we are streaming live right now, not just on YouTube, but you can also check us out on LinkedIn, Facebook, X, and also on Instagram. So do make it a point to connect with us and subscribe to our channel at Immigration Talk Show. That's our handle. And yes, I think we should definitely take up our questions. And without further ado, Prashanthi, if you could tell us what are the most common reasons travelers, including visa holders and even US citizens, they are facing, after long, I mean, they are facing longer interrogations and delays at the border. So, what are the most common reasons for that?
Well, I guess the reason is the present administration is cracking down, and there are several executive orders issued with reference to travel. So there's 212F, which is being used which basically says that the president has broad powers to suspend or impose restrictions on the entry of any aliens into the country if such entry would be detrimental to the interests of the US. So that's 212F is being used, is likely to be travel ban, complete travel ban for certain countries under this 212F. We've heard that there's countries designated with different colors. There's orange, red, and yellow. So red is, if the countries come under red, then they're not allowed to travel at all. If they are countries under the orange color, then there'll be some travel permitted, but it might be very restricted. And yellow countries would be those countries which have 60 days to address any of the administration's concerns with, with reference to what their countries are doing, reciprocity. So the list is not yet finalized, and we're waiting to see which countries will face that travel ban, and this is being done under the Section 212F. Also, discontinuance of visa issuance for recalcitrant countries. So this is under 243D. We're not aware right now of this being used for anything for any countries as a reciprocal measure. If they are not, treating U.S. citizens well, then as a reciprocal measure, then their citizens also won't be, allowed to enter into the country. But we haven't seen that being used as yet. Another one that they're using is 212A's 3C. This is basically authorizes the Secretary of State to exclude any individual whose entry or proposed activity in the United States is they have reason to believe that that activity would have potentially serious adverse foreign policy consequences for the U.S. So DOS, Department of State policy targets, for example, to give an example, they've targeted current and former Thai government officials responsible for returning UKRs from Thailand to China. So, there's specific examples such as that. Also, Department of State policy targeting foreign officials and others facilitating illegal migrants into the United States. So those bodies and those foreign officials who they feel are facilitating illegal immigration into the US, they may restrict their visas. Also, the Colombian visa issuance, there was an incident where they stopped issuance of visas to Colombian nationals. So, that's some of the policies under which the present government is stopping nationals from entering into the country. Recently, there's been a policy alert actually today, April 2nd. So this is updated information as new as it gets. April 2nd, 2025. We've seen that the present administration is not that keen on recognizing more than two sexes, and they've said that, and they've amended some forms also. Now there's a policy alert today recognizing male and female sexes in USCIS benefits forms, and also, with if Department of State and the visa issuance form, where they're asking for whether you're a male or female, they expect you to put whether you're male and female at the time of birth. Before, in the benefits forms, in certain USCIS forms, you were allowed to put gender as X. Now they're basically gone back to saying that it has to be either male or female at the time of birth. And so if people don't indicate their sex in their application form, or they put an X or something like that, then they will not, the USCIS is saying that they will not deny the benefit or deny entry, but it might cause delays in processing, delays in, also maybe entry into the US as well. So that's something to keep in mind with reference to what's happening. But otherwise, in general, and also at present with the present administration, it's important to understand what can cause delays or difficulty in being allowed back into the country. So basically, inconsistent travel history or frequent trips that raise suspicion. This has always been the case, and even more now because there's more vetting now, as per the administration's executive orders of having more extreme vetting uh, before allowing people into the country. So, inconsistent travel history. If you travel a lot, maybe to countries that support terrorism, and if they have no reason to travel there, then that could raise flags. If you're traveling often on a visitor's visa, for example, a visitor's visa is supposed to be used for travel and visit, not to live in this country. So if they see that out of 12 months you've been in the country already for 10 months, traveling back and forth, that could cause suspicions. If you've had any prior visa violations, overstays, or had some past immigration issues where you were stopped at the border, and you were vetted or sent for secondary inspection, that could be something that you should watch out for this time when you're traveling as well. If you're on the watch list or some security database, if you have a name match, maybe a common name, maybe it's a mistake because you share a name with somebody else who's on the watch list, that often causes issues with the entry into the US. If your purpose of visit, if you're a non immigrant, um, is not clear and you don't have the proper supporting documents. For example, if you're coming on a B1 to attend a conference and you're not able to, explain to the officer you don't have proof of why you're entering or information about the conference, or if you're entering on a H1 and you don't have proper H1 documentation, or you're not able to answer questions as to who your employer is, what your job is, where your work site is, or if you're responding and the responses are conflicting with the information that they have, then there could be problems. Possession of items that uh, it seems suspicious, like you're carrying a large amount of cash, that could be problematic. Social media activity that contradicts your stated intent to travel. So if you're coming on a B1, but your social media activity shows that you're actually working or you're traveling, coming back on an F1, but your social media activity shows that you're being paid, even though you have no work authorization, that could create problems. But also nowadays they are vetting people, then their social media activity for anything that they see that might be political, or if they have some views that are against, present US policies, they're looking at that as well. And also, any social media activity that shows that they are, a security hazard, um, that could be a problem also. Just to give you an example, recently, scientist was sent back because there was something in his social media which says that he didn't agree with the healthcare policy of the present administration. So just give you examples of that to be and what to watch out for. Also, you could just have random secondary inspections as part of routine security measures. So it could be just random um, stoppages or sending you for secondary inspections, and those random inspections will be much higher now because there's extreme vetting when compared to previous. So there might not be any reason at all. Maybe they're stopping 1 in 10 people. So it could be just a random stop. So those are some of the things to keep in mind, Nabasa.
Right. And I also hear that, our social media, WhatsApp, and everything is being asked. I mean, if they want to check in, especially during in the ports of entry. So, do you want to say anything on that note as well?
Yeah, as I said about social media, that um, you obviously have to be careful about what you put
Yes.
in your social media. You should remove or make private any posts that could be misinterpreted as violating your visa. For example, if you're coming on a B1, you might have something that shows that you are going for a job interview, that could be misrepresented as, you having a job in the US.
Hmm.
So you have to be careful about those kind of posts.
Yes.
Also, your social media should align with your, as I said, your purpose of your travel. So if you're coming on a visit, you're saying that you're a visitor and you're coming for pleasure, but you see some business related posts on your social media that you're going to be meeting clients, etc. That could be, that could be a conflict with what you're saying to the officer is your purpose of travel.
Right.
And also anything with reference to unauthorized work, controversial topic, politics, disagreeing with present government and their policies. Any of this could, attract scrutiny, as I said, with reference to the example of that scientist who was not allowed into the country.
Right, right. So it's always best to cooperate, friends out there, especially those who are traveling and who are asked, if you have if they have any questions with regard to WhatsApp or social media. I think you will just have to cooperate, and if you do not cooperate, you could be detained or even, delay your entry to the United States back again. So thank you, Prashanti, for that detail.
I mean, I guess
Yeah.
the best thing would be to remove any such, social media, and or to keep a separate, like, a work phone and an off and personal phone, so that both are not mixed up, or a device, separate devices.
Mhm.
And I should be following my own advice because I do a lot on my phone. But yeah, in general, I mean, also encrypting your social media may not would again raise suspicion. So don't do that as soon as you're traveling, or don't delete posts just before you're traveling. So just follow common sense,
Right, right.
and just be aware that there's heightened scrutiny with the present government, which might not have been there before. So be on guard.
Yes, always best. All right, so Prashanti, I would just like to quickly say hello to Christopher and Selomit. Thank you so much for joining us. And, we are going to take up your questions. Do stay with us. Also, friends, check out Immigration Talk Show. That's our handle. Subscribe to us if you haven't already. And yes, hit that bell icon so that whenever we have these interesting webinars, we have guest attorneys, you will be notified and you can join in so that you don't miss out on any important update or information. And also, don't forget to check out attorney Prashanthi Reddy. Go check out her website, www.reddyesq.com, to get to know more about attorney Prashanthi Reddy. And if you want to consult with her, why don't you call her up or email her? Her number is 212-354-1010. Or, yes, go email attorney Prashanthi at reddyesq.com. All right. So moving on, Prashanti, I do have more questions. So, how can tourists and visa holders ensure that they're not flagged for violating their visa intent when entering the US? We've already touched a bit, but if you could just tell us what exactly they can do.
Right. Well, first of all, they have to clearly state their travel purpose and make sure it aligns with the type of visa that they have. So, for example, if they say that um, something, it can be subtle. For example, you might have a B1 and B/B2 visa. Most people, everybody has a B1, B2 visa. You can use that either for work or for pleasure. But when you're entering into the country at that particular time, you have to state a particular reason. So if you're coming just to travel or to visit, you should say, who you're visiting, why you're traveling. But if you kind of say that, you intend to travel, but you also have, some business in the US, then it could be a mixed signal that you're sending, because they issue either a B1 or a B2 at, when they issue you an I-94 at the port of entry. So keep it clear as to whether it's business or whether it's, pleasure. Carry documents that will support your intent. If you're saying you're traveling, you don't intend to stay beyond 2 months, say, or 3 months, whatever the time you say that you want to stay, make sure you have a return ticket to show that you intend to return on time. If you're on a H1, for example, a work visa, make sure you're carrying your employment letters and your proof of employment and your, H1B approval to show that you intend to work in the US with that particular employer. As I said earlier, avoid carrying work related material if you're entering on a tourist visa. Be consistent in your responses. And as I said earlier, avoid giving conflicting statements. So all this can help you show that you have, what your intent is, and if you're on a non-immigrant visa that requires you to show that you have the intent to return, make sure you have documentation showing that.
Absolutely. I think that's what the US is looking for. If it's a visitor's visa, they just want to know exactly and for how long. And yeah, thank you so much, Prashanthi, for taking that up. And at this moment, I think we should take up Christopher's comment, not keep him wait too long. So, Christopher's saying, if I'm selected in the H1B lottery but can't make it to the US in time for the start of my job due to continued travel restrictions, what are my options? And will my employer be required to wait for me to enter the US, or do they have to hire someone else?
There's no immediate deadline for you to enter the country. Your H1, if it's filed for 3 years, will be valid for 3 years. You go for a visa, they will, if the H1 is for 3 years, you'll get it for the visa as well for 3 years. And you can travel anytime during the validity of that H or that visa. Of course, the more you delay coming into the US, the more you'll be questioned at the port of entry as to why there was a delay. And you'll have to carry updated information to show that, your job offer is still valid. With reference to your employer, he is not bound to anything. He can decide at any point of time to withdraw your H1 and to hire someone else.
Thank you for taking that up for Christopher. Thank you, Christopher, for participating. Don't forget to subscribe to our channel. And we now have Selomit. It's a long question. Attorneys often advise against carrying electronic devices or using a basic phone when entering the US to avoid scrutiny. However, doesn't this strategy potentially raise more suspicions with customs and border protection officers, ultimately leading to a more thorough and detailed vetting process? I also would like to know, do the officer at the port of entry have the right to ask us to log in at any of our social media account in their computers?
Yes, so I'll answer the last question first. You can refuse, you have some rights when you're entering. Of course, the rights are not the same as if you are already in the US. You have many more rights once you enter the US. But at the port of entry, you can refuse to cooperate. But the thing is that then you may not be allowed into the country. Um, yes, they can ask for social media handles, and if you refuse to cooperate, they can say that that can arise, suspicion, and you may not be allowed into the country. So of course you can refuse, but then you won't be allowed into the country. And as I said, your rights are limited when you're at the border when compared to when you're actually in the country. But you do have some rights of refusal when you're at the border. Uh, so, what is the other question? Carrying electronic devices, right? So, I don't advise my clients not to carry. I mean, you don't need to carry a laptop, right? That's a given. But yes, most people have a phone, and a phone has become so essential now that it might seem suspicious if you don't have a phone. So, how do you can't even call a taxi if you don't have a phone to get where you need to from the airport, or to contact someone who's picking you up, right? So yes, a phone has become a must, and it would seem weird if you didn't have one. But all we're saying is that if you have a lot of information on your phone which is unnecessary, then you don't need to carry all that information, right? You don't need to have emails on the phone. You don't need to have your social media handles on your phone. So that's what most attorneys advise, not to carry a lot of unnecessary information on the phone.
No, but I mean, they do need, in fact, even to save. I mean, nowadays everything is on cloud. You need to have your email. You need to, I mean, people are so used to their phones, right? They have the social media. So, I mean,
Well, maybe if you know that you're traveling, then don't have it on the phone.
But then again, it'll raise more
Especially
suspicion,
because,
right?
yeah, just keep it for what the purpose of the phone is, which is, calling a number. You don't need to have all that other stuff. You can have that on your computer.
Hmm.
You don't need to have all that on your phone. So I would suggest to delete all your handles and delete your email as well before you travel. But don't just do that for the sake of traveling because that would also raise suspicion.
Right, right. And plus, I think you'll be knowing beforehand if you're traveling, I mean, months beforehand. So you might as well do it gradually to avoid all sorts of suspicion. Thank you so much, Prashanti, for taking that up for Celomit. And now we have Papa Kipari on Prashanti's channel. Thank you so much for joining us, Papa Kipari. What options can I try if 221G takes so much more than 6 months? Should I transfer my petition to a new employer, which is a much reputed as compared to consulting company?
You could, but you could face the same 221G because you don't know what is the reason. I mean, if you know what is the reason for the 221G and you think that they're not able to overcome that issue, then yes, definitely you can file for another H1. It is cap exempt since you've previously filed for a H1. It got approved. It's not called a transfer because you have to be in the US to file a transfer, but you're filing a new cap exempt petition to another employer to overcome the issues that are in this 221G, perhaps.
All right. So, well, Prashanti, I do have more questions. And if you could tell us, what legit rights do travelers have, when they subjected to extended questioning or device searches at the border?
We just talked about that a little bit, but at the US borders, travelers have, as I said, fewer protections than within the US. However, they do have some rights. They have the right to remain silent, although refusing to answer will lead to a denial of entry, may lead to a denial of entry for non citizens. Of course, citizens, they cannot deny entry. Right to withdraw an application for admission if you, rather than being removed, if you find that at the port of entry, the officer doesn't find you admissible, they will sometimes allow you to withdraw your application and leave the country rather than be put into removal proceedings and then have a bar for 10 years from ever entering the country again. So you certainly have the right to withdraw your application. Um, and as I said, US citizens can't be denied entry, but they may face further scrutiny if they refuse to cooperate. The right to request for legal counsel, unfortunately, you do not have that right at the border, but you are allowed a phone call, even if you're being deported or removed from the country. So you're allowed that phone call. You should ask for it, and during that phone call, you could then ask for, legal counsel. But there's no right to legal counsel at the border.
Okay, that's another very interesting point to keep in mind. Thank you so much, Prashanti, for taking that up. And if you could also tell us, how much authority do border officers have to inspect personal devices? And what are the best ways for travelers to protect their privacy without raising suspicion? I mean, we've been touching on this a bit already for quite some time, but if you could tell us what can border officers do?
Yeah. So CBP officers do have broad control to inspect phones, laptops, social media accounts. So to protect privacy, travelers can store sensitive data in the cloud and travel with minimum device data. So put everything on the cloud. It doesn't have to be on your device. For example, a lot of people have their bank account app like I do. My bank account app on my phone. So they'll have access to that also to see how much money you have. And you don't want them people having looking at your bank account information. I would avoid encrypting or deleting apps just before traveling, as I said, because this might raise suspicion. I would try to use separate work and personal devices to minimize the risk of both things being mixed, and you don't have to carry a work device. You can just carry your personal phone. Um, so if you, of course, don't comply, as I said, non-citizens can risk being denied entry. So that's the problem with not complying.
Well, thank you so much, Prashanthi, for taking that up. And folks out there, don't forget to subscribe to our channel. We are at Immigration Talk Show. That's our handle. And you can also hit that bell icon so that whenever we have discussions like these, you are notified. And another best thing is that you can join us on this discussion to ask your question. And you can dial in this number 425-436-6335, and the access code is 988-888. Also, keep commenting. I can see Cynthia already joining us. Hi, Cynthia. Thank you for joining us on YouTube. So, she's asking, can individuals who are no longer eligible for the visa waiver program due to travel history or dual nationality still apply for a visitor visa? And what are the chances of approval?
So individuals who are no longer eligible for visa waiver program due to travel history or dual nationalities. Yes, so visa waiver is different from a visitor's visa. A visa waiver allows you to travel into the US if you're, say, a Canadian national without having to apply for a visa. But you can also apply if you don't want to go with a visa waiver program. A Canadian national can also apply for actual visa. And the same things are looked at with a visitor's visa. They look at intent, whether you intend to immigrate to the US, whether you have any ties, immediate family in the US where you might, then immigrate, whether you have ties to your home country, whether you have a job, whether you have how you're doing financially in your home country, whether you have relatives that you need to go back to. All this shows intent and shows ties. So they look at the same things when you apply for a visitor's visa. And I don't see why you cannot apply for a visitor's visa. You will not be eligible because of dual nationality.
Okay.
Unless you
Thank
belong
you
to
so
a
much.
country, where, unless you belong to a country where you have been, if that country has been banned, if there's a travel ban, we're likely to see travel bans in the future. So if you have a dual nationality and one of the passports you hold is from a country which has a travel ban, then you might be in trouble.
Okay, there you go, Cynthia. You have your answer. Thank you, Prashanthi, for taking that up. And I think this brings me to another question that I have for you. And if you could tell us, what precautions should travelers take regarding the social media? Well, we've discussed this, so I'll go on to my next, which is, if a visitor is denied entry at the airport, what is the best course of action to avoid severe consequences like deportation or future visa bans?
Well, if you're denied entry, first of all, you have to find out why you've been denied. So politely ask and request the reason in writing, um, as to why you've been denied entry. Request that for your application to be withdrawn. So say that you would like to withdraw your application for admission so that you're not removed from the country and you do not face a 10-year ban. Avoid signing anything without actually understanding what the consequences are. Um, so, oftentimes when you go into secondary inspection, they will have an interview and they will write down everything that happened during the interview, and they'll ask you to sign it, based on which then they will try to remove you from the US. Make sure you read it, because they might put stuff in there which you'd never said. Because they have to maintain a record of everything, just in case you decide to appeal it, go before a judge and say that then they might put you into detention. Um, and then that written record is important, then the judge will go through that, especially if you're a permanent resident. I know we haven't touched upon this and we need to, but permanent residents also are facing scrutiny at the port of entry. A lot of permanent residents are worried about traveling. All I have to say to them is that If you come from one of those countries that are likely to be banned, or after they get banned, then even if you're a permanent resident, you should not travel. But otherwise, if you have not been arrested at any point of time, not violated your status, and if you are maintaining your residence and you are living in the U.S. and you're not just using the green card to travel to the U.S. and you're actually living in India or in some other country, a lot of parents we know don't actually live in the U.S. They live in their home country and they use the green card just to travel back and forth. Those people will definitely face scrutiny if they are not living at least more than 6 months in a year in the US. But if you're just traveling, as a permanent resident, of course you can. There's no issues. You should only keep in mind what I said. And if you are one of those people who need to watch out for one of the issues that I pointed out, then you have to worry about traveling with a green card. Otherwise, you don't. So again, if you are traveling on a green card and they say that you have not been, you've been traveling a lot, you've not spent enough time in the US, then you have, and if they're refusing you entry, then you can say that you would like to be admitted and that you will go before a judge. That is your right. They cannot refuse you entry, but they will then detain you and then they'll bring you before a judge, and then you can, the judge will question whether you maintain residence or not. Oftentimes, a judge is much more liberal at granting you entry to the US and keeping your green card than the officers are at the port of entry. So keep that in mind. Don't blindly give up your green card unless you don't mind doing so, because you might think it's a pain to maintain your green card and you'd rather give it up and get a visitor's visa instead. So but depending on the circumstances, don't just blindly agree to sign something or give up something without understanding the consequences. If you give up your green card, then you'll be sent back and you may not be able to come back into the country. You might be able to apply for a visitor's visa, of course, but be aware that the options of filing a green card again might not be there for you, especially if you got it based on employment. If you got it based on family, it's possible that you might be able to get the green card again by filing again. But that's a delay and it could be several years before you're able to get it. So, if possible, contact an immigration attorney. If you're formally removed from the country, this can trigger future bans. It could be a 10-year ban or a 1-year ban. You may be able to appeal it at the consulate, but you certainly will not be able to appeal it at the port of entry. So after you're removed, you might be able to apply for a visa again and apply for a waiver at the consulate. So that is, some of the actions that you can take after you've been refused entry.
Okay, thank you so much, Prashanthi, for taking that up and for telling us about it. So, also, the ongoing challenges with the H1B visa process, including cap restrictions. If you could tell us, what are some of the alternative visa options for professionals who were not selected in the lottery?
Yes, so as I said, the lottery results are out and they are all out. We don't expect any more results to be trickling in. Um, so you have to either look to see if you might get selected in next lottery if they have another lottery, or you have to look for alternatives, or you can file, of course, your registration the next year. Some of the alternatives are the O1 visa, which is for individuals of extraordinary ability. So if you are also extraordinary ability in your field, so if you're an IT professional, you've developed an app, you've done something that's creative or extraordinary, then you could definitely try and apply for an O1. You can apply for an L1. Your company can sponsor you for an L1 if you're an intra-company transferee, meaning that you're working for a foreign company and they're transferring you to the US subsidiary or parent, and you're working as a manager or an executive. Then you certainly will qualify for an L1. You can qualify for a TN, it is a TN is also a work visa, but that's for Canadian and Mexican nationals. But you have to also qualify under the NAFTA, meaning you have to be under the list of designated occupations under NAFTA to qualify for a TN, and you have to have not only be on not only should it be one of those jobs, but you also have to qualify under the list of qualified professionals, meaning for a software engineer, you should have a bachelor's in computer science because that's what is required under that list, just to give you an example. If you qualify again under an E2 visa category as a treaty trader or treaty investor, you can come on an E2 either as an employee or as an owner of the company. And L1 also can be an employee or owner of the company. Or you can file for an EB2 national interest waiver, sponsor yourself, or EB1, not just multinational executive, EB1 green card, but you could also be EB1 extraordinary ability. So you can come directly on a green card, especially if you come from a country that doesn't have a backlog for EB1 or has a short backlog. You can avoid the H1 completely and come directly on a green card. Of course, if you have family members who are immediate relatives, you can file for a green card based on that as well. You might also be cap exempt if you're working for a cap exempt employer or if you've previously held a H1 at some point of time. A cap exempt employer is a non-profit research organization or a governmental research organization, or universities are also cap exempt, or a university that is related to a non-profit um, educational institution. So basically, a hospital that is related to a university could also be cap exempt. So you could be a teaching hospital, for example. You could be a hospital that is affiliated with a university, a medical school, say, or a nursing school. So that would be so if you're working for one of these organizations, or if you have an end client who is one of these organizations, and you may be working for a consulting company, then also you are cap exempt. So those are some of the ways that you can come
Options.
in if you are not selected, yes, for a H1.
Thank you so much, Prashanthi, for taking that up. And friends, join us in this conversation. Fawad, thank you for joining. If you can join us on call, do join us. And this goes out to all you folks out there. Join us on 425-436-6335. And when they ask for the access code, just dial 988-888. Also, don't forget to hit that subscribe button and, subscribe to our channel at Immigration Talk Show. Hit the bell icon so that you are notified, and yes, Fawad, let's take up Fawad's question. Trump administration is circulating three risks. Yes, Fawad, we started with this actually, and I wish you were there when we started this. Session today. Red, orange, and yellow of countries that would be subject to different scopes of bans, and new Trump travel ban could ban Afghans, Pakistanis soon, sources say. Does that mean that we won't be able to apply for any visa at any point of time?
As long as the travel ban exists, and depending on which color code you are, they like color codes. So depending on which color code you are, you if you are, for example, orange, if you're red, then you can't apply at all until the travel ban is listed. You cannot apply for any visa. If you're orange, it could be that certain visas you'll be able to apply for and certain you won't be able to. Maybe investors will be able to apply, but regular B1, B2 visitors may not be able to apply. Just to give you an example, yellow is, of course, they are looking to see whether they should put a travel ban or not on these countries. So that remains to be seen as to what the final outcome will be. So yes, if it's red, then you won't be able to until travel ban is in place, until they remove it. And orange, you may be able to, depending on the type of visa that you're applying for.
Okay, there you go. Thank you so much, Fawad, for joining in with your question, and thank you, Prashanti. So now we'll take up some of our Facebook
Sure.
questions from our Facebook groups. Prashanti, if you're ready. And Control, if you can please display the questions.
Sure.
Let's go with the first. Con- yes, Control, if you're there, could you please display the first question from our Facebook group? Okay. Anyone got I-140 approval through premium processing recently? How long it takes now?
Yes, I mean, we apply for I-140 premium processing regularly. There's no change in that. And it takes, it's supposed to take 30 days. They're supposed to respond within 30 days with an RFE or an approval. And sometimes, I mean, most of the time it takes less than 30 days, a few weeks.
Okay. All right. So let's go on to our next Control. If you can display again, please. Probably there are some issues, but no worries. Control if you can figure it out. And meanwhile, Prashanti, I still have some more questions from my end. And if you could tell us, how are these increased border security measures affecting H1B workers who travel abroad and return to US on a valid visa?
Right, since we're talking about H1s, let's talk about what extreme vetting is taking place for people coming on H1. So definitely there's extra questioning about their employment status and job duties. Um, there's delays. If the employer has been flagged for some H1B violations, then people coming in through those companies, they might face delays or extra scrutiny. There's also scrutiny over whether they're genuinely working for that company or not. So they want to make sure that there's an actual job, uh, and they're not going to be, the job is not speculative. So sometimes they're even contacting the employers, contacting the clients, even at the port of entry to make sure that the job exists as of the time of their entry into the US.
Right.
So, I mean, considering all this additional scrutiny, it's advisable to carry your recent pay stubs, your employment verification letters, of course, copy of your H1B petition. And especially if there was a delay between the time that you got a visa and the time that you actually came into the country, very important to carry your updated employment verification letter or offer letter, your updated client letter or vendor letter or purchase order to show that the job still exists. Especially some people who are traveling now, when they got the visa last year from the last cap, you should definitely carry these documents.
Yes. I hope you're taking notes, friends, and thank you, Prashanti, for highlighting that as well. So now let's go back and to take some more questions from our Facebook group. So, Control, please zoom in a bit. What are the current processing timelines for I-140 in regular filing?
About 6 to 8 months.
Okay. This is from Prashant. Thank you so much for taking that up. And now let's go on to our next. So sorry, I actually have to zoom in a bit, I think. All right. So, hi, I just received an RFE medical um, I-693 for my I-485, but didn't receive for my wife and my daughter. Sorry, you'll have to zoom out again. Okay. And my daughter who are on my EB5. Should I send all of them or just mine? Little worried they just throw the two others. Let me know, what do you think? Thank you for your help. Sylvian is asking.
You should send what they're requesting for. If they have not requested for your wife and daughter, maybe they don't need it. But they're requesting for you, so you should definitely send it in. And there's no point in sending for your wife and daughter because that's going to go into the garbage. If they don't request it and you send documentation, they just throw it in the garbage and then they ask for it again. So you're losing money or losing effort and time in sending what they're not asking for. Just send what they ask for.
Right. Right. Thank you, Sylvian, for asking your question. Now let's go on to our next. And this is from an anonymous participant. Hi, everyone. I'm currently on H1B extension and will max out in next 2 years. My employer has denied filing perm I-140. What are my options apart from H4? What is the other way to file I-140? Also, what if I am with employer A who is not able to file I-140, but I am filing perm and I-140 through employer B? If it is approved, can I stay with employer A and have H1B extended based on the approval of I-140 from employer B? If I get another opportunity with an XYZ employer in future, how does that work?
So, the first question is, what are my options apart from H4? What is the other way to file an I-140? You can always file an I-140 in a national interest waiver where you don't need an employer. But of course, you have to qualify for that, and very few people qualify because you have to show that it is within the interest of the United States to give you a green card. And that's a pretty high burden, right? You could also, I mean, your spouse can file since it looks like that you have the ability to be on a H4. Your spouse can file for the green card if her employer is willing, and you could be a dependent and get the green card that way. You could also have employer B file your labor cert in I-140. But remember, the ability to pay may be an issue. If you're not on the payroll of employer B, which you will not be since you're on the payroll of employer A, then they have to show that they have the ability to pay you the prevailing wage. And that, since you're not on their payroll, they can only show through their tax return. And by showing profit in their tax return of 120K or 150K or whatever the prevailing wage might be for your job. But you could certainly file if they do have that kind of money in their tax return and they have not filed any other green cards. Because if they have filed other I-140s, then they look at the total number of cases filed in order to show ability to pay. If I get the opportunity, so the other question was, can I stay with A, continue to work with A and file my green card through B? You certainly can do that. But my suggestion is at the time of when the date becomes current and you are ready to file the 485 or after, at least after you get your EAD, make sure that you work for that employer because if you don't, then there's a possibility, if you never work for the employer, then there's a possibility at the time of filing your citizenship or even at the time of, if you're getting a green card interview, they might ask you why you are not working for employer B. Is there actually a valid job offer or not? Um, so that's something to keep in mind. I think I answered.
Right.
If I get another opportunity with XYZ, how does that work? So if you filed a 485, then you can transfer that, and your I-140 is approved, you can transfer that to XYZ. Otherwise, you could transfer the I-140 priority date to XYZ if the I-140 has been approved at least 6 months ago.
Okay. Well, thank you so much, Prashanthi, for answering each of these questions for anonymous participant. And we do have another one. This is from another participant. Hi, all. I have a query for a critical case. If my employer terminates my current H1B and I have until the end of May to find another job as a grace period, what are my options to remain in the US in a legal status? And if I'm not able to find another job within the grace period, what are the complexities of me switching from F1 or day one CPT? And if I switch, do I have to do that within 60 days grace period before my legal status completely expires? And if I have time until the end of May and I look for challenges for enrolling in fall season, that is August, what is my status between the time period from day my H1B expires, end of May, up to August when my session starts? Or should I be looking for a summer admission only? And what are my options here other than enrolling to school or F1? Any leads are highly expected.
Appreciated. Yeah. Um,
Appreciated,
so
yes.
he's saying that there's several questions, so I think we need to break it down. Um, I have a query. If my employer terminates my current H1, I have until the end of May to find another job as the grace period ends in May, I guess. Yeah. What are the options remain in the US? You can certainly file for a change of status to an F1. You can file for a change of status to a B2. A lot of people do that. And then while that B2 is pending, you can then, um, if you get a job while the B2 is pending, within that 6 month period, you can then apply for change of status back to a H1. You have to remember that the B2 processing time is more than 6 months, so you might ask for 6 months, but by the time they actually process the case, the B2 will become invalid. So within that 6 months period that you ask for, you have to do whatever you need to do. That is change status or extend status. So that's something to keep in mind with reference to the B2. You could also do F1. Day one CPT is possible, but the school has to require the day one CPT, should allow it. It should be part of the curriculum. Say if it's a kind of an executive program where, you know, classroom work and internship goes together, complementing one another, then day one CPT certainly is possible because that's the way the program is structured. If I switch, do I have to do that? Yes, you have to do that within the 60 days grace period, whatever you do, before your status expires. Um, if the other interesting question that they're asking is if the college starts later and you get the approval earlier, then what happens? You have 30 days to start your program. Once you get status. So talk to your DSO and find out if you need to be covered, if you can take summer courses, or whether you'll be covered. You should definitely file for a premium processing to make sure that you get it. It's more predictable as to when you get it, because otherwise it might take beyond August, because regular processing takes sometimes to 8 to 10 months. So you have to be careful about not going over August, right? Because then the fall session would have started and you would not be able to join. You'll have to join in the next session. And that's, gets very messy then.
Absolutely. So true, Prashanti. Thank you so much for taking them up, this question as well. And I think with that, we have completed taking most of our questions from our audience. So thank you so much, Prashanti, for patiently taking up each one of them. And, if we still got some time, I could, pick up one case study because, we had a skilled professional on H1B travel visa abroad and upon returning was subjected to additional questioning and temporary hold despite having a valid visa stamp. So how can H1B workers, prepare for re-entering and what documents should they always carry to avoid complications? If you could just give out a few tips before leaving us, it'll be great.
Yeah, so always make sure that your answers are consistent and not inconsistent with the application that was filed. Um, and also make sure that you carry all your documentation, like I said before, because there's more vetting now. Make sure you carry that employment letter. You fly into wherever your work is, because then they'll question you as to why you're flying to a different airport unless you have a valid reason for it. um, Also, be aware of what kind of questions could be asked. Be prepared with responses. um, carry all the documentation. Notify your employer as to when you're traveling, so that they will be on call in case the consulate has any questions to ask them. Have them send one of their representative to the airport if possible. so that again they'll be close by in case they're called in for questioning. So these are some of the things that you can do to ensure that your entry is smooth.
Well, thank you so much, Prashanthi, for answering that as well. And friends, please do not forget to subscribe to our channel. It is at Immigration Talk Show. We are on YouTube, and you can also find us on LinkedIn, Facebook, X, and Instagram. And also go check out Attorney Prashanthi Reddy. So in case you need a one-on-one consultation, you want her to check out your case thoroughly, and yes, you could call her up. Her number is 212-354-1010. And you can also email Prashanthi, and her email address is prashanthi@readyesq.com. And go visit www.readyesq.com to get to know more about the law offices of Prashanthi Reddy. So thank you so much, each one of you, for joining us, and also Fawad, Fawad, Cynthia, and all you folks out there today who joined us, Selomid, and also Christopher, and of course many others from our Facebook groups. So thank you once again. Very happy that you could join us. And please feel free to also ask your questions if you want to WhatsApp me. My number is 408-335-6444. And my email address is nipa@staffingly.com. So it was really lovely having you with us today, Prashanthi, and really looking forward already to another session that's coming up.
Thank you. Same here.
So, friends, check out Attorney Prashanthi Reddy and the law offices of Prashanthi Reddy for sure. And also check us out, Immigration Talk Show. That's our handle, at Immigration Talk Show. And with that, I'd just say stay tuned on our channel because there's a lot more updates coming, and even other shows that you do not want to miss out, because yes, it's also, we have something called Daily Immigration Dose, where I and my co-host Sam, we host. So join us there as well. It'll be really nice to have you. Thank you once again, and bye for now. Have a good day ahead.